We have said that Mr. Zuma should pay a punitive cost. We have explained why a punitive cost is required. But the most important element is that he is acting with malice. The utterances that Mr. Zuma has made are malicious utterances. He is also acting without any facts. Mr. Zuma completely disregards the evidence. He just launches on an attack that is completely bereft of fact. Once you combine the malice and the untruthfulness, it becomes quite clear that a normal cost order is not sufficient, that he should pay a punitive cost order, attorney and clients. That would be an appropriate penalty in addition to sending him to jail for 2 years. I have nothing useful to say, Justice Khampempe. That will be my address to the court.
Mr. Mugai-Toby, on the question of costs, a punitive cost order is usually granted against a litigant for the court to show its disapproval for the manner in which that party has litigated. Mr. Zuma has not opposed these proceedings.
No, Justice Theron, that itself, in a contempt against a former president, that itself is warranting of a punitive cost order. Because what this court deserved, at least, is an explanation. It did not even get that explanation. And that failure to provide an explanation is simply part and parcel of the malicious behavior of Mr. Zuma.
But Mr. Mugai-Toby, you have submitted to this court that the failure to give an explanation should be taken into account in respect of the length of imprisonment.
Yes.
So must it be taken into account in respect of the length of imprisonment and a punitive cost order as well?
Yes, Justice Theron, that's exactly the point I'm making. I'm saying to the court that his malicious conduct includes the failure to give an explanation to this court about what he has said about the political campaign that he has embarked upon against this court. And it includes the fact that after he has been called upon to explain himself as the former president, he decided that he won't explain himself. That is also part and parcel of the deliberate and the calculated strategy to discredit the court. So it's relevant on both the length of the imprisonment and it's relevant on the scale of the cost. In other words, it does not make it less malicious just because he has not filed an affidavit. It in fact makes it more malicious because it shows that he had no explanation for making those remarks. And he could not even be bothered to apologize to the court.
So, Mr. Mugai-Toby, what you're seeking is for the court to set a precedent against waging lawfare through the constitutional and other courts.
Lawfare,
is that what you're looking for?
Lawfare justice play is a respectable term, and one does not want to attach that label to this kind of egregious, unjustified, untruthful conduct. This conduct falls apart from lawfare. Lawfare, in fact, will lose meaning if it is attached to this type of behavior. So what we are asking for, yes, perhaps you could, if you are to expand the meaning of lawfare, but what we are asking for is that people should not wage political campaigns on falsehoods against members of the judiciary with no consequences. And here, a former president should not do that. So yes, the precedent is crucial, but the court needs to protect the institutional integrity of the judicial system. Justice Khampempe, I'm in your hands. I've got nothing more useful to say to the court.
Thank you, Mr. Mugai-Toby.
Sorry, my junior seems to have sent me something. I know it's been overtaken by events.
Yes. Thank you, Mr. Mugai-Toby. Judgment is reserved and the court is adjourned.
Thank you. Thank you, Justices.